Yeah. As Rolf said, I'm senior partner of the firm. I'm in the business for 21 years, I believe. I have a PhD in neuroscience, but do only molecular biology since I'm a patent attorney. So that's basically what you need to know about me. This presentation today is basically it's a mission impossible to get you an overview about the CRISPR-Cas situation in general and also about prime editing and the integrase-based variants. I'm just trying to highlight some specific issues, and maybe if you want to clarify, if you have a specific problem that you want to go into, this presentation can at least serve as a starting point, just to give you some basic orientation where you have to go and where you have to look. And of course, I mean, if you get lost, feel free to contact us, because we can certainly help you in solving your IP problems in this specific field. Well, that's for the beginning. I think I don't have to tell you that CRISPR-Cas is a mess when it comes to patents, and that there is a terrible patent dispute going on for more than 13 years now. We are now in year 13 after the first CRISPR-Cas9 patents have been submitted, and we still have no clarity about who is having the upper hand, who is having rights on what. So the baseline is already very murky, and of course, if this would not be enough, there's now also prime editing and other things which make the thing even more complicated. So what I'm trying to show you is that even though there's already a patent dispute ongoing with regard to CRISPR-Cas9 and also to a lower extent to CPF12, Cas12a, there seems to be a new chain of dependencies to develop, which is now about to unfold, and that makes establishment of freedom to operate even more complicated than it is with CRISPR-Cas or 9 or Cas12a alone. And by the way, we have published a lot of things about that. If you want to have reprints for these papers, please let us know. Well, let's just very, very briefly start with CRISPR-Cas and the connecting point to prime editing. So when you use CRISPR-Cas for genome editing, there's basically two pathways. One is homology-directed repair, and the other one is non-homologous end joining. And when we want to integrate foreign DNA into a given genome, the method of choice in this microcosm is HDR. With HDR, you can integrate, at least literature says it. I have no practical experience because I'm not a scientist anymore, so I have to rely on what I read in literature or what clients tell me. So the length of the DNA insert in HDR is about maximum 2 kilobases. But what is important here, both CRISPR-Cas approaches require double-strand breaks. Well, then a scholar from Fang Zhang, David Liu, also from Broad Institute, then came into the idea to develop prime editing. By the way, that's not the only technology he has developed. There's also base editing, which I will only very briefly touch here in one specific aspect. So this is not about base editing. This is about prime editing. So what prime editing essentially is or uses, it uses a fusion protein that comprises a programmable nickase, for example, an NCas9. N stands for nickase, or Ncas12a, and that is fused to reverse transcriptase. Very specific example, for example, you have a Cas9 with a mutation MH840A, which makes a nickase out of it, and that is then being used together with a reverse transcriptase from MLV virus. What else you need is you need a prime editing guide RNA, and that is used when it is used has a double role. First of all, it identifies the target site and it directs the enzyme complex there too, like it does in Cas9 or in Cas12a. But in that prime editing guide RNA, there's also a stretch which provides the new genetic information that is meant to be integrated into the genome. I come to that later. Just a very brief overview. What you see here. Do you see my mouse pointer? Rolf, can you check? Do people see my mouse pointer?
Yes, we can see
perfect.
that.
Okay, perfect. So this is the Cas9 enzyme, or maybe also the Cas12 enzyme, and this is the reverse transcriptase that is fused to the to the enzyme, and here you have RTT stands for the reverse transcriptase template, which essentially is the RNA counterpart to the genomic information that is then integrated into the genome. So what it does, first of all, CRISPR Cas doesn't require a double-strand break, and that makes it much more safe and reduces off-target effects. It uses the cell's intrinsic DNA mismatch repair system. It is less dependent on the precise position of the pump site, so it provides more flexibility. As said, it doesn't require double-strand breaks. Well, because there's 3 separate DNA binding events, this is an approach to increase target specificity, reduce off-site effects, and however, relative to homology-directed repair, the size of the edit, meaning the size of the fragment that can be integrated, is limited. And typically, according to literature, it says that size ranges between 50 and 400 base pairs. And that's, of course, markedly shorter than what is, for example, possible with CRISPR-Cas9 when using HER. Now, David Louis was not lazy when he developed prime editing. He went on, not only that he also developed base editing, but he also had the idea to combine prime editing with an integrase. And in that specific case, and I simply go back to this slide, the reverse transcriptase template is not actually the gene of interest that you want to integrate, but you use this passage here as that is the landing site for an integrase. So you're not, by means of prime editing, you're not integrating the gene or the sequence of interest, but you are integrating a landing site for an integrase. And that landing site, for example, can be an add-P or add-B site for the integrase BXB1. And then the integrase identifies or recognizes this, what we call landing site, and can then insert the real sequence that you want to have into the genome. And that's called, sometimes it's called cargo DNA, but I have a couple of other names which I'll share with you later. So, and in that sense, this combination of prime editing integrase is really a further development of prime editing. You are not integrating by the prime editing approach the sequence as such that you want to have into, but you are integrating the landing site, which is then used by the integrase to integrate the sequence that you really want to have into. And with that approach, you can integrate stretches of several kilobases into the genome. That approach has been baptized first TwinPE, but then I think now the working title that is being used by David Liu and Prime Medicine is called PASSIGE, which is an acronym for, I don't know. Anyway, read it up. Now, here you see that, so you have like a threefold enzyme system. You have the Cas9 enzyme, you have the reverse transcriptase, and then you have, for example, the BXB1 integrase, which then eventually helps you to integrate the gene of interest that you want to have really into the genome. Now, so far so good. Now it becomes complicated because Prime Medicine is not the only company that is offering this technology. There's a spin-off from MIT that was, because it has gone bankrupt, called Tome Biosciences, and they have developed an approach that they called PASTE. And apparently that approach has a lot of similarities to PASSIGE. It uses a programmable nickase. It combines the nickase with a reverse transcriptase to first write a short DNA stretch into the genome, and then it can use, for example, the BXB1 serine integrase and its recognition sequences to integrate DNA fragments as large as 50 kilobases. Sounds familiar? And there were public discussions ongoing about in how far both methods are actually different from one another. There's a lot of secondary literature that is devoted to that topic. And when you read the literature, you read about speculations that for example, which of the integrase landing sites is actually used at B or at P. And well, some articles write about that in some cases the three enzymes would be tethered physically to one another or linked covalently, or whether they simply work independently. But anyhow, from the patent perspective, this all doesn't actually matter. If you ask me, I think that from the patent perspective, these two approaches are technically largely identical, or at least in very highly similar. Well, if that would not be complicated enough, there's another company, that's Tessera. And Tessera is one of the companies that has been created or sort of synthesized, or however you may want to call it, by that company Flagship Pioneering that also created Moderna. And they use a toolbox which they call GeneWriter. And well, information on PASTE and PASSIGE is scarce enough, is difficult to find enough. But for GeneWriter, it's really difficult to find really comprehensive or understandable information of what actually is being used in that approach. And when you go to the website from Tessera, what they're actually speaking about is that they have a toolbox which encompasses different elements like an RNA binding domain, a DNA binding domain, a nicking domain, and a reverse transcription domain. And what they allege is that they can combine these different elements for the specific purpose that is being required in order to edit a given genome. And that has been subject of a lot of criticism, and David Liu in an interview has actually stated that it would simply look like Tessera merely changed the name of prime editing to gene writing, and that of course sounds like trouble in some way or the other. I just did my best to really understand the technology that Tessera is offering, and it appears to me that the rewrite approach is somewhat similar to the regular prime editing, whereas the write approach, because it seems to encompass the use of an integrase, seems to be like PASSIGE or PASTE be more similar to those two approaches. Well, and now patents come into play. We haven't spoken about patents yet. Now patents come into play. And that is, as I said, all these three elements seem to use a nickase. And that nickase can, for example, be a Cas9 nickase with any of the substitutions that I mentioned here, either in the RAFC domain or in the HNA domain, or they can also be a Cas12 nickase with the substitutions in the RAFC domain, because Cas12a doesn't have an HNH. And that automatically means that if you want to practice any of these methods, you may be required to have a license for using the Cas9 nickase or for using the Cas12 nickase. And this sort of shoots us back to the underlying patent dispute regarding Cas9 and Cas12a. And I have a table here for this. I hope this is readable enough. Otherwise, I'd be happy to share the underlying Excel tables if you just drop us an email so I can share the Excel tables. These five patent families are what I sometimes call the seminal patent families of CRISPR Cas. And you have all these applicants sound familiar to you people: University of Vilnius, University of California, University of Vienna, that is the Charpentier-Doudna group, Tulgen from Korea, who has actually just sued Vertex in Europe for its sickle cell anemia treatment. Then it's Sigma Aldrich, or now Merck Millipore, and Broad Institute in Harvard. And I mean, they all have filed what we call basic Cas9 patents in 2012, which sometimes leads me to the question, what did you people do in 2012, or what did I do in 2012? I don't fully recall what I did actually then, but obviously this must have been a magical year. So when you analyze these different patent portfolios, you identify patents in those portfolios which explicitly claim a nickase. And that, for example, holds true for the Vilnius patent family, for the University of California CVC patent family, and also for the Broad. Whereas Tulgen and Sigma Aldrich, at least from my prima facie analysis, even though they mention nickase in their texts are basically restricted to double-strand breaks, so they would not be relevant background IP with regard to being used in the prime editing context. But probably because all these three portfolios use or disclose or claim nickases, there might be a requirement to have a license from any of them or from all of them. And whoosh, we are back in the basic Cas9 patent dispute and the legal uncertainty that it creates. Now for Cas12a, the situation is a little bit less complicated. There's of course University of Wageningen, but let's keep that aside for a moment. The patent family that has been filed by Broad Institute has members that also claim nickases that have claims on nickases. And here I just this is from the Excel table I told you. This Y stands for yes, meaning that the respective search term is appearing in the claims as granted. So point one, it appears that if you want to use prime editing or any one of the further developments, you may be required to have a license for Cas9 or for Cas12a, depending on what you use of the two. Now we try to sort of sort from one another the different approaches and the patent portfolios that have been filed in order to protect them. And I have another table, but before I just want to go through this text here. As said, these three approaches seem to be highly similar. It appears that prime medicine has at least an earlier priority date than Tome Biosciences. You need to know that Tome has shut down operations in November 2024. However, the patents were licensed in from MIT, and as such, they are still there. So the portfolio that Tome relies on is still a factor when you consider freedom to operate, even though Tome does no longer exist. Tesra has openly argued that they might have developed the technology first, that is the GeneWriter technology, which is a little bit difficult to understand just from the information that the company is spreading. But we could identify a patent family with a member that has been filed that dates back, or the patent family dates back to August 2018. And this seems to outdate both Tome's and Prime Editing's key patents. I'm showing you that in a minute. The patent is like the public information that Tome is spreading is a little bit difficult to read because it also speaks about different elements in the toolbox. But when you read it thoroughly, it sort of stings a little bit in terms of, or smells a little bit in terms of that it really seems to encompass. It has language that can be read on prime editing and PASSIGE and paste. And here are the patent families that I spoke about. So this is one of the members of the flagship or Tesra patent family. And at least when you look into the claims, it uses the terms reverse and transcriptase, which sort of lets you could make it think, maybe we need a second eye to have a second eye on that, because it looks a little bit that there would be at least prime editing involved. Then you have the two prime editing patent members here, which are a little bit more elaborate. One of them even speaks about BXB1, which lets you think that this might really cover prime medicine's PASSIGE approach, whereas the first patent family here does likely read on the basic prime editing. And then there's the patent family from MIT, licensed in by Tome, who no longer exists, which also use all the different terms here. So it seems we have a new patent conflict here looming here in this behind us. I had a second eye on the flagships patent because I was really surprised that they have this early priority date and went in stealth mode for a while. And interestingly, in the patent portfolio, or in this patent family assigned to flagship or Tesra, 20 of the 30 examples are actually written in present tense, which I find very interesting. And when you read the examples, you also find that the language has sort of speculative character because it, right, it can be done and it seems like, and then the results are described in present tense or even in future tense, just like the genomic integration will be higher than. And I mean, this suggests, and you already know it, this suggests that those experiments haven't actually been performed. Because I mean, under US law, it is admissible to use hypothetical experiments, but then you have to use future tense or at least present tense. So in other words, these experiments are actually prophetic. And that of course can sort of cast doubts on the question whether that early patent portfolio that has been assigned to Flagship is actually enforceable. So I would be not surprised if we see litigation coming up on this, and if we see litigation coming up on this, that enforceability or let's go back, let's say enablement could be an issue here, or written description, and that resonates in the reality. I came across an interview with Prime Medicine's CEO. He has the name Keith Gottesdiener, which really sounds funny in German, but anyway. And he told investors that Prime Medicine would prosecute their gene editing patents very aggressively in the future. So we can here expect trouble. Okay, that's complicated. And then there's also the prime editing guide RNA. I mean, a prime editing guide RNA is a molecule, and as such, people could try to create composition of matter protection for the prime editing guide RNA. This looks typically like that. You have the spacer. The spacer you also know from Cas9. That is the sequence that's sort of takes care, or that's the targeting sequence. Then you have the scaffold. The scaffold, that is a sequence within the guide RNA that does the interlock with the enzyme. And now, then specifically for prime editing or for PASSIGE or PASTE, you have the reverse transcriptase template, and you have a primer binding site. And that's basically an illustration from Tome's patent family, with a spacer, as we know it from Cas9. Then the gRNA scaffold, we also know that from Cas9. And here you have the reverse transcriptase template and the primer binding site here. There's a lot of different names for this reverse transcript template. Sometimes it's called heterologous object sequence, but even other names are running around. I show you some. Here I have it. So the reverse transcriptase template sequence is also sometimes called heterologous object sequence or extension arm, sometimes also, and that is actually, it all means the same. It's the template for the reverse transcriptase to transcribe the DNA sequence that includes the edit, and that would be in prime editing. That would be actually the sequence of interest that you want to have integrate into your genome, and in PASSIGE or PASTE, that would be the sequence of the landing site for the integrase, like for example the 38 base pair long add-B site, which is this sequence. Now, I had an eye on, in order to understand whether there's also a looming patent disputes with regard to this prime editing gRNA, I just tried to analyze the situation for sickle cell anemia. You may know that this disease is caused by a single base pair point mutation in the beta chain of adult hemoglobin, and then you have an E6V substitution, and that substitution leads to the phenotype that you see, and that makes people's lives so difficult who are suffering from sickle cell anemia. I could identify 3 patent families that claim or that describe a prime editing or prime editing / integrase approach in which a prime editing gRNA is disclosed. And that is, surprise, again, one patent family assigned to Flagship, pioneering, meaning Tessera, another one from Broad Institute, meaning prime editing, And another application, and that surprised me, which has been filed by Beam Therapeutics, the other company that David Liu has founded. And Beam Therapeutics is not basically, they are basically focusing on base editing, not on prime editing, but still they have a patent here in which they claim the use of prime editing for treatment of sickle cell anemia. And when you look through that, you see that the spacer sequences, at least in the broad patent application and in the flagship patent application, are identical. And you see also that the scaffold sequence in these two is identical. And when you just make clear that here in this application, in the Beam application, they use the RNA language in which T has been replaced by U, then you see again you have the same sequences here for the spacer sequence and for the scaffold sequence. Now, probably not surprising because you want to address the same gene, but what's interesting is, well, the secret is in the extension arm, meaning the heterologous object sequence. And here I did some analysis. The first one is, this one is shows you the extension arm sequence of the broad pattern family, and you see this is the translated amino acid sequence, and this is here. This is the This is the protein sequence, the first 10 amino acids with the wild type here. GAG is encoding for E, and then here you see the disease phenotype with E6V. Here you see the valin instead of the E here, and here you see the triplet that is encoding for that. So here you have single base replacement. A has been turned to U and then causes the diseased phenotype. When you look into broad patent portfolio, patent application, this is the sequence. This is the extension arm sequence, and that encodes for exactly this amino acid sequence. So the idea would be to step in here at the second position and here replace the wrong V by the correct E. Now, basically, Flagship and Beam are doing more or less the same. This is a little bit shorter. This is a little bit more like N-terminal, but in any case, they are doing pretty much the same. And I'm not saying that this will eventually result in a patent dispute. It may or may not, depending on how broad the extension arm sequences are claimed. For example, if Broad has claimed this would be the extension arm sequence or a fragment thereof, then it could be expected that the Flagship or Beam pegRNAs would fall under that. But what's probably even more interesting is how do these different approaches perform in reality in the clinic? And that is, of course, something that's difficult to predict at this point of time. Well, no patents have been granted from the free patent estates yet. And because neither prime editing nor Tessera nor Beam have a respective therapy on the market, it's probably too early to predict or exclude a possible patent dispute between these rivals. So what I'm trying to only to show you is that this smells all a little bit like trouble. I think we can expect that something is happening down the road here in this specific field. Yeah, this is basically the two patents I spoke about, but there are even further ones that should be looked into when you consider freedom to operate with regard to the specific approach in sickle cell disease. But of course, there's a lot of other hereditary diseases which could be treated with prime editing or its integrase-based variants. So I believe that this exercise has to be done with your specific application that you have in mind. Maybe one last point, and that is also, I think, very interesting. And I try again to show this on the example of sickle cell disease. You all know Casgevy, which is an approved therapeutics from Vertex for the treatment of sickle cell disease. Here, the patients undergo apheresis, and so that means that CD34 positive hematopoietic stem cells are being taken from the patients, and they are then edited ex vivo with CRISPR-Cas9. And what's done here is it's not the gene is not the incorrect gene is not corrected, but actually the BCL11A enhancer is disrupted, and that means that the fetal hemoglobin is reactivated in these cells. Fetal hemoglobin, which is typically switched off during human ontogenesis. So the idea is to replace the incorrect adult hemoglobin by reactivated fetal hemoglobin. So it's a slightly different approach. But what's important here is this is an ex vivo approach, meaning that CRISPR-Cas in this specific approach, at least in my understanding, is not part of the therapeutic entity. The therapeutic entity are the edited hematopoietic stem cells. The CRISPR-Cas in this approach is just a tool because it is actually happening outside of the body. And I would be interested to hear your opinion on that thing. Now, when you think about prime editing, or even also CRISPR-Cas, there's also considerations to use these approaches in vivo. By using targeted lipid nanoparticles, which comprise an RNA encoding the endonuclease plus the donor template and the gRNA or pegRNA, so that this type of editing can be done in vivo, either in LNPs or, for example, in virus-like particles. And because these LNPs or VLPs are administered to the human body, and because they comprise the endonuclease or the prime editing system, I would think that in this specific approach, this in vivo approach, the CRISPR-Cas9 or the prime editing is in fact part of the therapeutic entity. And that's a big difference, whether it's just a tool, like in this approach here, or whether it is part of the therapeutic entity. Because if it's part of the therapeutic entity, one could assume that it is subject to the Hatch-Waxman exemption or the Bowler provision, meaning that research and development in which CRISPR-Cas9 is used for such in vivo approaches, because CRISPR-Cas9 is part of the therapeutic entity and as such is also subject to the regulatory approval, that in vivo uses would be privileged and would not infringe third-party patents. The question is, if CRISPR-Cas9 is only used ex vivo, and in that understanding, I would think it's likely to be considered more a tool than to be part of the therapeutic entity. I would think it's probably arguable whether Hatch-Waxman or Bowler apply to the use of CRISPR-Cas in those specific ex vivo approaches. In other words, for ex vivo uses, there's a likelihood that patent licenses are likely to be required, while for in vivo use, at least as long as it is only R&D and not yet on the market, in that case, the use would be privileged or likely be privileged by Hatch-Waxman or Bowler. That's basically my last slide. Just to give you an idea, this first group of patents here, these three ones, illustrate the lifetimes of what I sometimes call the seminal Cas9 patents. And in particular here, you remember that 3 of the 5 who explicitly also claim nickases. Then there's a second group here that is Cas12a, that has a longer lifetime because it has been filed later. Then in this this white area here, we have the different patent families that are discussed that, well, read on prime editing and or integrase-based variants thereof, just to give you an idea about the lifetime of this complex. And then this third group illustrates the prime editing RNAs for sickle cell disease that are being used, that could then be used with any of these technologies. Just to give you an idea about the lifetimes of these and of these different patent portfolios. And this, in a way, sort of illustrates how freedom to operate would have to be established even with regard to other therapeutic approaches where not sickle cell disease is is the disease to be treated, but for example, whatever, hemophilia or you name it. Yes, that's my presentation so far. I understand that it may raise more questions than it answers, but the idea has simply been to sort of, in one example, show you how freedom to operate approach would have to be carried out, where the starting point is, where maybe critical patent families are, what to consider. And so in order to facilitate, if you are interested in establishing freedom to operate in this field, to just give you a starting point and sort of organize your approach a little bit better than if you would have to start from scratch. These are 2 articles. The third one is basically devoted to the topic I've just discussed. That is submitted and is now in the reviewing process. The other ones are published. Feel free to ask us for copies. I'd be happy to share. And that's basically it. Thank you very much.
Thank you, Uli. That was very interesting. I learned a lot. And we already have the first question from the audience. Let's suppose there's a recombinant protein on the market whose expression falls under a claim of these patented technologies. How easy is it to police the technology for patent holders? Aren't cell banks and the specifics of vectors for recombinant proteins supposed to remain non-public?
Well, that's actually that's difficult. I don't know. Well, if the recombinant protein is a therapeutic protein, I would assume that. But I'm not an expert in regulatory law. But I would assume that the documentation requirements imposed on you by the regulatory authorities require some kind of disclosure how the recombinant protein was made, and then whether or not that information is public, I don't know. And of course, I cannot give you, at least not publicly, any advice how to bypass or how to sort of misuse or ignore third-party patents simply by relying on that this will never go public. But I mean, in the end, if for a patent holder there's no chance to find out in which way the recombinant protein has actually been made, then the patent holder will have a problem. That is for sure. I do not think that on that basis it would be recommendable to ignore third-party patents. But as said, if there's no public documentation on how that protein was actually being produced, then the patent holder has a problem. I mean, the burden of proof is on the patent holder, but we have seen a lot of cases in the past where such kind of information reached daylight by one channel or the other. I mean, there's definitely a risk in doing that. I hope this is satisfying.
So are there any other questions? Now is the chance. Or, of course, you can always contact Uli later on via email or just call up. So, but now is the chance to have some more questions. Yes, we have another question. As the field is moving so quickly, there is strong concern for unpublished or submarine patents, which weighs heavily on the companies and investors. How can one brace for these? Oh, tough question.
Yeah. Well, first of all, we live in lucky times because even in the US now, patent applications have to be published 18 months after filing. So that is now in harmony with the rest of the world, because until I think June 1995, patent applications weren't published at all in the US, but only granted patents were published. And you see this in the Inbrel case, where just a granted patent surfaced, I think 2018, which then had 17 years of extra lifetime. That is no longer the case. That does no longer happen in the US. But of course, I mean, the problem of unpublished patent applications is a big issue. Whenever we do freedom to operate, actually we always only look into the past, and we have a blind spot for the last 18 months. So it's good advice to, when you do a freedom to operate study, it's good advice to repeat that freedom to operate study after like 18 months again, just with the same search algorithm, simply to see whether something has surfaced which didn't catch you, which you simply couldn't find because it was not yet published. I I wouldn't think that this is the biggest problem. I think the problem is already there because the patent landscape is so manifold and it's so difficult to navigate that even if that problem of non-published patent applications would not exist, it's still complicated enough to find your way through this thicket. But technically, if you are preparing a product launch or whatever, it's definitely recommendable to repeat your FTO study or the underlying patent search 18 months after you did it for the first time.
Yeah, Uli, I just find that you do this all the time. You talk about this internally in our meetings. So yeah, it's very difficult work to find your way through these patent thickets, but that's our job basically, or your job.
Yes,
in this case, in the biotech field.
Yes, and just maybe to ease people's mind, I think we didn't have, well, I think the biotech patent community was sort of taken by surprise by this magic year 2012 when 5 different entities have filed patents for more or less the same subject matter at more or less the same time. We knew that from other technical disciplines like mobile communication, where this happens every other day, and where now after like 20 years or 30 years of negotiations, there are at least tools to manage such a situation. I think we biotech people are still in a learning curve how to handle these situations. I think it is, I mean, it doesn't provide any relief to those people who are affected by this situation, but I think it's really well, the last time we had that, no, it's not correct. No, it's not. I wanted to draw a comparison to PCR, but that's not correct because PCR was pretty much in the hand of one company, that is Roche. But here we have like 5 big players who are more or less rivaling about who actually is allowed to bear the fruits. And that is something I hope that that the biotech community will be able to settle these things in the future. But I think, well, the patent authorities were completely overwhelmed by these 5 rivaling patent pools. And you see it until today that they are not able to sort of really manage the situation.
Yes, thank you very much. To all in this call, we will be publishing this in a couple of days on our website, including the recording and maybe also the slides. So feel free to stop by our website, and of course, feel free to contact Ulrich Storz with any questions you might have after this call. So no more questions. Uli, any final words?
No.
Okay, all right.
Thank you.
So let's see you next month in our webinar, and feel free to stop by our website. Thank you for attending. We are very grateful. And yeah, thank you very much.